The metallic groan of the automated gate, usually a familiar comfort, now echoed with a chilling emptiness. Sarah pulled her hand from the worn fabric of her sweatpants, the phone clutched uselessly within her fingers. No, it couldn't be her. Eyes darted frantically across the asphalt of the community parking lot, each space glaringly vacant where her lifeline should have been. The morning sun, usually a cheerful beacon, felt like a harsh spotlight exposing her worst nightmare. Her accessible Honda Odyssey van, her modifications, her entire world on wheels. It was gone. A cold dread seeped into her bones, quickly replaced by a hot wave of panic. "Buddy, where's the van, boy?" she whispered, her voice tight. Beside her, Buddy, her magnificent golden retriever service dog, cocked his head, his gentle brown eyes mirroring her confusion. He nudged her hand, a soft whine escaping him, as if sensing the sudden shift in her carefully constructed calm. Buddy was more than a pet. He was her anchor, her guide through the chaotic landscape of her PTSD, a constant presence that allowed her to navigate a world that often felt overwhelming. And his purpose, his very ability to perform his life-saving tasks, was inextricably linked to that van. Just yesterday, she'd meticulously parked it in her assigned spot, the one closest to her ground-floor unit, marked clearly with a blue and white accessible parking sign she'd personally bought and installed after getting the HOA's written, albeit reluctant, approval months ago. She remembered running her hand over the sleek lines of the power ramp before locking it, a familiar ritual that spoke of independence and freedom. Now, only a phantom outline remained on the shimmering blacktop. Her heart hammered against her ribs, a frantic drumbeat against the silence of the early morning. This wasn't just a car. This was her mobility, her independence, her access to medical appointments, to the grocery store, to the veteran support group that kept her grounded. Without the van, she was stranded. And without the van, Buddy couldn't perform his critical tasks outside their small apartment. Tasks like guiding her through crowded spaces, retrieving dropped items, or even just providing the deep pressure therapy that pulled her back from the brink of a panic attack. Her mind raced, frantically sifting through possibilities. Was it stolen? No, that couldn't be. This was a gated community, with security cameras positioned at every entrance. A carjacking here felt impossible. Then the chilling thought solidified. The HOA, the Homeowners Association. A knot tightened in her stomach. Their relationship had always been strained. Ever since she moved into the Lakeshore Heights development, a sprawling community of cookie-cutter homes and meticulously manicured lawns, the HOA had treated her modifications. The ramp, the grab bars in her bathroom, even the small discreet service dog on duty sign she wanted to put on her door. With thinly veiled suspicion, they were a stickler for rules, for uniformity, for a pristine image that it seemed didn't quite include the visible signs of disability. Taking a shaky breath, Sarah pulled out her phone. The HOA office didn't open for another hour, but she knew the emergency towing number was posted on a sign near the main gate. She dialed, her fingers fumbling, each ring echoing the emptiness in her chest. Lakeshore Heights. "Towing," a gruff voice answered, laced with the impatience of someone awakened too early. "Hi, my name is Sarah Jenkins, and I live at 14B Lakeshore Heights. My accessible van, a silver Honda Odyssey, is missing from my assigned spot. I need to know if it was towed." Her voice was a tight wire, strained with forced calm. A brief pause. "Jenkins, 14B? Yeah, that one. Towed at 3 a.m. Violation of parking regulations." The voice was flat, devoid of empathy, like a robot reciting. A pre-programmed message. Violation? What violation? Sarah's voice rose, incredulous. "It's my assigned spot. I have a valid accessible parking permit and the HOA approved the spot for my accessible vehicle and service dog." "Doesn't matter. Vehicle was parked on the yellow curb line. Clear violation. You'll have to pay the impound fee and daily storage. Pick it up from our lot on Elm Street." The gruff voice cut her off, dismissive, then added, "Management requested the tow, not us. Take it up with them." A click, and the line went dead. Sarah stared at the phone, the dial tone buzzing in her ear like an angry hornet. Yellow curb line. That was impossible. Her spot was clearly marked directly adjacent to the curb, but not on it. She always made sure to leave ample space for the power ramp to deploy without obstructing the sidewalk. This was a lie, a deliberate misrepresentation. Buddy, sensing her distress, nudged his head into her lap, then gently placed his paw on her knee. His signature. Her comfort cue, Sarah leaned into him, burying her face in his soft fur. The warmth of his presence a small comfort against the rising tide of indignation and fear. How could they? How could they be so utterly callous, so willfully blind to her needs? It wasn't just an inconvenience. It was a direct assault on her independence, a cruel reminder of how fragile her autonomy was when confronted with bureaucratic indifference. The next hour felt like an eternity. Every minute without the van was a tangible loss. She had a physical therapy appointment at 10 a.m., crucial for managing the chronic pain in her back. How would she get there? Calling a taxi or a rideshare with Buddy was always a gamble. Many drivers refused service animals despite the law. Even if she found one, it wouldn't be accessible, meaning she'd have to struggle in and out, risking further injury. The thought of having to reschedule, of losing progress, filled her with despair. When the HOA office finally opened its doors, Sarah was there, Buddy patiently sitting at her side, his service dog vest clearly visible. The air inside the small sterile office felt thick with unspoken rules. Mrs. Henderson, the HOA manager, a woman whose perpetually pursed lips seemed to be surgically attached to her face, looked up from her computer, her eyes narrowing slightly, as she took in Sarah and Buddy. "Good morning, Mrs. Henderson," Sarah began, trying to keep her voice level despite the tremor in her hands. "My accessible van was towed early this morning. Lakeshore Heights Towing said it was at the management's request for a parking violation. I need to understand why." Mrs. Henderson sighed, a long suffering sound. "Ah, yes, Miss Jenkins. Your vehicle. We've had several complaints." She picked up a thin file from her desk, flipping it open with an air of theatrical importance. The vehicle was observed consistently impeding the yellow curb line, despite numerous verbal warnings. "Verbal warnings? Mrs. Henderson, that's simply not true," Sarah countered, her voice rising slightly. "My van was parked precisely within my assigned spot. I was given specific approval for that spot because of the ramp for my accessible vehicle, and I have never received a verbal warning from you or anyone else." Mrs. Henderson lifted a perfectly sculpted eyebrow. "Perhaps you misinterpreted our informal advisories. Regardless, the curb line is a no parking zone. It's a fire lane, Ms. Jenkins. Safety is paramount." She tapped a manicured nail on a printed photo in the file, a blurry, poorly lit shot of her van, seemingly at an odd angle. It was clearly a manipulated image, or taken from a perspective that distorted the reality. "But it's not a fire lane. Directly in front of my spot. My spot is parallel to the curb, not on it, and my van is modified for my disability. It's essential for my service dog's accessibility. You are violating the Americans with Disabilities Act, ADA, by towing it without just cause, especially when it hinders my accessibility." Sarah felt a surge of anger, but also a growing realization of the deeper problem. This wasn't just about a parking spot. It was about their blatant disregard for her rights as an individual with a disability. Mrs. Henderson's lips pursed even tighter, forming a thin, unforgiving line. "Ms. Jenkins, the HOA has the right to enforce its parking regulations to ensure the safety and aesthetics of the community. Your personal modifications do not exempt you from these rules, and frankly, this discussion is unproductive. Your vehicle is at the impound lot. You will need to retrieve it and pay the fees. She closed the file with a definitive snap, dismissing Sarah with a wave of her hand. The dismissal hit Sarah like a physical blow, the absolute refusal to acknowledge her disability, the casual invalidation of her legitimate concerns, the callous disregard for the massive inconvenience and financial burden they had just imposed on her. It was infuriating. She stood there for a moment, gripping Buddy's leash, her knuckles white. Buddy whined softly, leaning against her leg, his warmth a solid presence amidst her crumbling composure. As she turned to leave, a wave of despair washed over her. Her physical therapy appointment was now impossible. She had groceries to pick up, but how would she get there? The impound fees alone would be hundreds of dollars, money she barely had in her limited fixed income. This wasn't just an inconvenience, it was a systemic barrier designed to wear her down, to make her give up. But then, as she stepped out into the bright, indifferent sunshine, a slow, burning ember of defiance ignited within her. They thought they could bully her? They thought they could strip her of her independence and get away with it. Not this time. Not when it impacted Buddy, her lifeline. They had just tangled with the wrong person. This wasn't just about a towed van anymore. It was about fighting for her rights, for the rights of every individual with a disability who faced similar ignorance and discrimination. The loop was set. A deep, profound injustice had been committed, and the only path forward was to fight back. Her mind, though reeling, began to formulate the inevitable next step. She would call a lawyer. The HOA had no idea what they had just started. The first day without her van was a stark, brutal awakening to the extent of her newfound imprisonment. Sarah canceled her physical therapy, a pang of guilt hitting her as she imagined the therapist shaking her head. Later, she struggled with a trip to the local corner store, her only accessible option by foot, the effort leaving her winded and her back throbbing. Buddy walked dutifully beside her, but the weight of his vest, usually a comfort, now felt like a burden, a constant reminder of the independence she had lost. That night, she lay awake. The image of her empty parking spot burned into her eyelids, the impound fees a looming shadow over her meager budget. The next morning, armed with a carefully compiled folder of documents, her accessible parking permit, the original HOA approval letter for her modifications, photos of her van properly parked, and Buddy's service dog certification, Sarah returned to the HOA office. She believed in approaching problems rationally, giving people the benefit of the doubt, even Mrs. Henderson. "Good morning, Mrs. Henderson," Sarah began, forcing a pleasant tone. "I've brought all the documentation regarding my van and my service dog. I believe there's been a misunderstanding. My van is an essential accessible vehicle, protected under the Americans with Disabilities Act. TOWs like this are considered discriminatory if they impede my ability to access necessary services due to my disability." Mrs. Henderson, who was meticulously arranging a pile of brochures, barely looked up. "Miss Jenkins, we've reviewed your case. The board stands by its decision. Your vehicle was in violation. The ADA, while important, does not override established community safety regulations regarding fire lanes and common areas." She pushed a piece of paper across the desk. A generic printout of the HOA's parking rules, heavily highlighted around. The "No Parking in Yellow Zones" clause. "But my spot isn't a yellow zone," Sarah insisted, her voice trembling slightly. "It's my designated accessible parking space, approved by the HOA, and my van was in the spot, not on the curb line." She pointed to her own clear photographs. Mrs. Henderson gave a tight-lipped smile that didn't reach her eyes. "Our security camera footage shows otherwise, Ms. Jenkins, and frankly, this discussion is taking up valuable time. We've explained our position. Your only recourse is to pay the fees and retrieve your vehicle." She then gestured vaguely towards the door. "Unless you have a check, I'm afraid I have other residents to attend to." The casual dismissal, the implied accusation of lying, the blatant disregard for the ADA, it was a slap in the face. Sarah felt her carefully constructed composure shatter. Her jaw tightened and Buddy, sensing her escalating stress, nudged her hand firmly. This wasn't a misunderstanding. This was outright stubbornness, perhaps even a calculated attempt to make her give up. She had offered them an olive branch, and they had snapped it in two. Leaving the office, Sarah felt a cold determination settle over her. She knew she couldn't afford the impound fees, let alone the ongoing daily storage. But more than that, she couldn't afford to let this stand. If they could do this to her, they could do it to anyone. This was bigger than a towed van. It was about her dignity, her right to live independently, and the principle of accessibility for all. That afternoon, Sarah started making calls. She Googled ADA Lawyers California, Disability Rights Attorneys Los Angeles. The first few calls were discouraging. Either too expensive, or they specialized in other areas of ADA law. Then she found Advocates for Independent Living, a non-profit legal aid organization. After a brief screening, they set her up with a pro bono consultation. A few days later, Sarah found herself in a small, bustling office across from attorney David Chen. He was a kind-faced man in his late 40s, with warm eyes and a calm demeanor that immediately put her at ease. As she recounted the entire ordeal, the approved parking spot, the essential modifications, the sudden tow, Mrs. Henderson's dismissiveness, David listened intently, occasionally nodding and taking notes. Buddy lay quietly at her feet, a silent testament to her need for assistance. "So, Miss Jenkins," David said when she finished, leaning forward, "this is a classic case. HOAs often believe their internal rules supersede federal law. But the Americans with Disabilities Act, specifically Title III, covers public accommodations, and even private entities like HOAs have obligations under the Fair Housing Act and the ADA if they provide certain services or facilities. Your vehicle being towed, especially given its modification and your service dog's integral role, constitutes a denial of reasonable accommodation." A wave of relief washed over Sarah. Someone finally understood. So, they can't just do this? Absolutely not. An accessible parking spot is a reasonable accommodation. Towing your specially adapted vehicle without proper justification and then refusing to acknowledge your disability can be seen as discriminatory. We have a strong case here, Ms. Jenkins. They've not only caused you financial hardship, but have also severely impacted your ability to live independently and access necessary medical care. David explained the first steps. He would send a formal, strongly worded demand letter to the HOA. This letter would outline their violations of the ADA and the Fair Housing Act, demand the immediate return of her van without fees, compensation for all damages, lost income, alternative transportation costs, emotional distress, and UYDT, commitment from the HOA to revise their policies and provide disability sensitivity training to their staff. "Think of this as our first warning shot," David explained. "It gives them a chance to rectify their mistake before we proceed with litigation. Many HOAs back down at this stage when they realize they're dealing with serious legal counsel." Sarah felt a flicker of hope she hadn't experienced since the tow. What if they don't back down? David's expression became more serious. "Then we prepare to file a lawsuit. It can be a long process, but you have the law on your side. We will fight for your rights." A few days later, a thick envelope arrived. At the HOA office marked legal correspondence. Mrs. Henderson, initially dismissive, paled slightly as she read the contents. The letter from David Chen detailed the specific statutes of the ADA and FHA they were violating, the extensive damages Sarah was incurring, and the intent to pursue full legal action if the demands were not met within a strict time frame. Her phone rang that afternoon. It was Mrs. Henderson, her voice now devoid of its usual dismissive tone, replaced by a strained formality. "Miss Jenkins, we received a letter from your attorney. We are reviewing it. We will be in touch." She hung up abruptly. Sarah felt a surge of grim satisfaction. The tide was beginning to turn, however slowly. But the fight was far from over. The van was still impounded, the fees still mounting. The phone call was just a momentary pause, not a resolution. The loop for the audience was now tightened. The initial battle lines had been drawn, the legal fight had begun, and the tension of waiting for the HOA's next move, or rather their lack of a move, hung heavy in the air. The stage was set for a protracted legal conflict where the stakes were not just a van, but the very essence of Sarah's independence and dignity. The silence from the HOA following David Chen's demand letter was deafening. Days turned into a week, then 2. Sarah's accessible van remained a prisoner at the impound lot, its fees accruing like a ticking clock, a constant drain on her already strained finances. Every rescheduled appointment, every missed opportunity to leave her apartment, fueled her resolve. Mrs. Henderson's brief, terse phone call now seemed like a hollow echo, a desperate attempt to buy time. "They're playing hardball," David explained during their next meeting, his expression grim but determined. "They obviously think you'll give up, or that they can outlast you financially. But that's precisely why we moved to the next stage." He pushed a stack of documents across the desk. "We're filing the lawsuit." The decision, though anticipated, still felt monumental. It transformed her personal struggle into a public battle, a formal declaration of war against the indifference of the HOA. Sarah signed the papers, her hand steady, a sense of purpose solidifying within her. Buddy, sensing the shift in her mood, nudged her arm reassuringly. A few days later, a process server, a stern-faced man in a crisp suit, delivered the legal summons to the HOA office. Sarah imagined Mrs. Henderson's face, a mixture of disbelief and fury, as she was officially served. The formal act felt like a small victory, a clear message that Sarah was not backing down. The lawsuit officially commenced, signaling the beginning of the discovery phase. This was a period of intense information gathering, where both sides exchanged documents, interrogated witnesses through depositions, and sought to uncover every relevant detail. For Sarah, it felt like an invasion of privacy and a relentless, uphill climb. The HOA's legal team, a formidable firm specializing in community association law, immediately went on the offensive. Their strategy was clear: discredit Sarah, downplay her disability, and portray her as a nuisance. They issued extensive interrogatories, written questions demanding detailed answers about her medical history, her income, Buddy's training, and every interaction she'd ever had with the HOA. They also requested voluminous documents, including all her medical records, financial statements, and even Buddy's vet records. "They're trying to bury us in paperwork and intimidate you," David explained, sifting through the demands. "They want to see if you'll crack under the pressure." Sarah found herself spending hours at David's office, meticulously going through old files, recalling precise dates and conversations. It was emotionally exhausting. They even tried to argue that her PTSD wasn't a true disability that warranted an accessible parking space, or that her van wasn't that essential, implying she could simply take taxis or rely on friends. "This is outrageous, David," Sarah exclaimed during one particularly frustrating session, tears pricking her eyes. "They're trying to diminish my entire existence. It's not just a parking spot. It's about my ability to function." David nodded, gravely. "I know, Sarah. This is why these cases are so draining. They strip away your dignity bit by bit. But every time they try to discredit you, they strengthen our case. Their tactics only highlight their discriminatory intent. One of the most challenging aspects was the deposition of Mrs. Henderson. David skillfully questioned her, exposing inconsistencies in her testimony. She maintained that the van was parked on the yellow curb, despite Sarah's clear photos. She claimed verbal warnings were given, but couldn't produce any record or independent witness. When pressed about the HOA's knowledge of Sarah's disability and the van's modifications, she became evasive, repeatedly stating, "We follow all procedures outlined in our bylaws," without directly addressing the ADA. "Mrs. Henderson," David pressed, his voice calm but firm, "are you aware that under the Americans with Disabilities Act, HOAs are required to make reasonable accommodations for individuals with disabilities? We are aware of all applicable laws." "Mr. Chen," she sniffed, her usual composure cracking slightly. "However, safety regulations, such as fire lanes, must be adhered to by all residents." She clung to the fire lane argument like a drowning person clinging to a life raft, despite David presenting architectural plans showing no such designation for Sarah's specific parking area. The HOA's lawyer, a sharp-suited man named Mr. Thorne, constantly objected, trying to protect Mrs. Henderson, but David skillfully navigated around his interjections. It became clear that the HOA leadership had an unwavering, almost arrogant belief in their own rules, even when those rules clashed with federal law. Then came Sarah's own deposition. It was a grueling 6-hour session, conducted under oath, with Mr. Thorne leading the questioning. He probed into her medical history, her military service, her daily routines, trying to find any weakness, any inconsistency. "Ms. Jenkins," Thorne began, his voice smooth and condescending, "isn't it true that you could simply call a taxi or a ride-sharing service? Why is this specific van so absolutely essential?" Sarah took a deep breath, Buddy's warm weight against her feet a silent source of strength. "Mr. Thorne," she said, her voice clear despite her rising anxiety, "my accessible van has a power ramp. Without it, I cannot easily enter or exit a standard vehicle without risking further injury. Furthermore, many taxi and rideshare drivers refuse service animals despite laws, leaving me stranded. My service dog, Buddy, is trained to assist me with mobility, balance, and providing deep pressure therapy during panic attacks. He can only do this effectively if we have reliable, accessible transportation. The van is not a luxury. It is a medical necessity. It is my independence." She recounted the struggles of the past weeks, the missed appointments, the isolation, the constant fear of being trapped. Her voice wavered slightly as she described the emotional toll, the feeling of being stripped of her autonomy. Buddy, sensing her distress, subtly nudged her leg, a small, comforting pressure that only she would feel. Mr. Thorne tried to paint her as litigious, as someone trying to exploit her disability for personal gain. He presented HOA bylaws that Sarah had supposedly violated. But David, on redirect, meticulously debunked each point, showing the HOA's selective enforcement and the clear pattern of discriminatory behavior. The discovery phase, while exhausting, proved to be invaluable. David managed to unearth several crucial pieces of evidence. Emails between HOA board members discussing ways to address the vehicle issue before the tow, indicating premeditation rather than a spontaneous response to a supposed violation. The original architectural plans of the parking lot, clearly showing Sarah's designated spot, was not a fire lane. Records of other residents without accessible vehicles being given warnings for minor parking infractions, but never immediate. Towing. The HOA's defense strategy became clear: deny, delay, and deflect. They continued to argue that the tow was justified under their bylaws, that Sarah's disability was irrelevant to the parking infraction, and that they had no obligation to accommodate a choosy resident. They even offered a small settlement, barely enough to cover the impound fees, with no acknowledgement of their wrongdoing or policy change. Sarah, with David's firm backing, immediately rejected it. This wasn't about the money alone. It was about justice and principle. The legal battle had officially commenced, and it was brutal. But Sarah, though weary, felt a growing sense of empowerment. She was no longer just a victim. She was a plaintiff, fighting for her rights. The loop for the audience was now tightly wound, the tension palpable. The formal legal fight had begun, and the question of who would prevail in this high-stakes battle loomed large, building anticipation for the dramatic courtroom showdown. The day of the trial dawned with a heavy, anticipatory silence. Sarah, dressed in a simple but sharp navy suit, felt a nervous flutter in her stomach. Buddy, ever vigilant, sat patiently by her side, his service dog vest a stark declaration of his purpose. As they entered the courthouse, the imposing architecture seemed to press down on her, magnifying the gravity of the moment. This wasn't just a legal proceeding, it was her life, her independence on display. Inside the courtroom, the atmosphere was a blend of formal solemnity and palpable tension. The rich wood paneling, the stern portrait of Lady Justice, the hushed whispers of onlookers, all contributed to the sense of immense stakes. Judge Miller, a no-nonsense figure known for his fairness, presided over the bench. The jury, a diverse group of 12 citizens, sat attentively, their faces unreadable. Across the aisle, Mrs. Henderson sat beside Mr. Thorne, their expressions a mixture of confidence and disdain. The trial began with opening statements. David Chen, calm and articulate, painted a vivid picture of Sarah's life, her service to the country, her invisible wounds, and Buddy's vital role. He emphasized the HOA's repeated disregard for federal law, portraying their actions as a callous attack on a vulnerable individual's rights. This case, he concluded, his voice resonating through the room, is about more than a parking spot. It's about dignity, access, and the fundamental right of every American to live free from discrimination. Mr. Thorne, for the HOA, countered with a dry, technical argument. He painted Sarah as someone trying to exploit her disability to circumvent community rules, emphasizing safety regulations and the HOA's responsibility to all residents. He argued the tow was justified due to a clear violation of the yellow curb line, presenting blurry photos as evidence. He dismissed Buddy as merely a pet in the context of parking regulations. The first major turning point came with Sarah's testimony. David guided her through the narrative, allowing her to recount the terror of finding her van gone, the immediate impact on her physical therapy and grocery runs, and the emotional toll of feeling trapped and dismissed. She spoke eloquently about her PTSD, how Buddy mitigated her anxiety attacks, and how the van's modifications were not a luxury but a crucial extension of her ability to navigate the world. Mr. Thorne suggested I could simply take a taxi, Sarah stated, her voice quivering slightly but firm. But how do I transfer my wheelchair into a non-accessible vehicle? How do I ensure a driver will accept Buddy? This van is not just a vehicle. It is my legs, my guide, my freedom. As she spoke, Buddy, lying beside her chair, let out a soft whine, as if in agreement, and then settled his head on her foot, a silent, powerful testament to their bond that was not lost on the jury. Mr. Thorne's cross-examination was aggressive. He tried to pick apart her memory, questioned the severity of her PTSD, and implied her need for the van was exaggerated. "Ms. Jenkins, isn't it true that you walk to the corner store on occasion?" He pressed, implying she didn't always need the van. "Yes, Mr. Thorne," Sarah responded, meeting his gaze directly. "But that 10-minute walk left me in pain for hours and risking further injury. It's not sustainable, and it's certainly not access. It's making do when my legal right to accessible transportation was taken from me." Her calm, dignified response seemed to resonate more deeply than any emotional outburst could have. The next pivotal moment was the testimony of the former HOA groundskeeper, a reluctant witness David Chen had painstakingly tracked down. This man, Mr. Davies, was no longer employed by Lakeshore Heights, giving him no reason to lie. He testified that Mrs. Henderson had specifically instructed him to find any reason to tow Sarah's van, citing vague aesthetic concerns and resident complaints about the large vehicle. He also confirmed that Sarah's spot had never been designated a fire lane, and that the photo provided by the HOA was taken from an angle that distorted the van's position, making it appear over the yellow line when it was in fact properly within its bounds. "Did you ever see Ms. Jenkins' van parked illegally?" David asked. "No, sir," Mr. Davies stated firmly. "Always in her spot, always careful. Mrs. Henderson she didn't like how big it was, how it looked different." This testimony struck a powerful blow to the HOA's defense. It exposed the tow not as a safety measure, but as an act of prejudice, confirming Sarah's suspicion of targeted discrimination. The jury members exchanged glances, their earlier neutrality shifting. The HOA's witnesses, primarily Mrs. Henderson and another board member, struggled under David's cross-examination. Mrs. Henderson repeatedly fell back on boilerplate rules and regulations, but she faltered when David presented the original HOA approval letter for Sarah's accessible parking space and then the actual architectural blueprints of the parking lot, which clearly showed no fire lane designation for that specific area. She was forced to admit that no written warnings had ever been issued to Sarah. "Mrs. Henderson," David pressed, holding up the blueprint, "can you show us where the yellow curb fire lane you cited is located in Ms. Jenkins' specific parking area?" Mrs. Henderson stammered, pointing vaguely. It's understood. Common sense, Mrs. Henderson," David retorted, "does not override legal blueprints or federal law." The room murmured. The trial culminated in the closing arguments. Mr. Thorne attempted to regain ground, arguing that regardless of intent, Sarah's van was perceived as an obstruction, and the HOA acted within its rights to maintain order. He tried to revert to the argument that the ADA was being overused, that it shouldn't dictate every trivial parking decision. But David Chen delivered a passionate, compelling closing argument. He wove together the testimony, the documents, and the human story. He showed the jury the direct link between the HOA's actions and Sarah's loss of independence. He reminded them that the ADA was put in place precisely to prevent this kind of systemic discrimination, whether intentional or born of ignorance. He spoke of the inherent dignity of every individual and the right to reasonable accommodation. "The Huer evidence," David concluded, his voice ringing with conviction, "has shown a pattern of calculated disregard for Ms. Jenkins' rights, driven by prejudice against her disability. This is not about a trivial parking infraction. This is about ensuring that no one, especially those who have served our country and live with a disability, is ever again stripped of their independence by the very people who are supposed to foster community. Send a message with your verdict, that the Americans with Disabilities Act has teeth and justice will prevail." The jury retired to deliberate, leaving Sarah in a state of suspended animation. The courtroom emptied, leaving only the echoes of the powerful arguments. The turning points had been made, the truth laid bare. Now, the fate of her fight, and the wider message it would send, lay in the hands of 12 strangers. The tension, almost unbearable, settled deep within her, leading directly to the dramatic reveal of the verdict. The courtroom was electric, charged with an almost unbearable tension. Every eye was fixed on the jury box as the foreperson, a stern-faced woman in a sensible gray suit, handed a folded slip of paper to the bailiff. The murmurs died down, replaced by a suffocating silence. Sarah's heart hammered against her ribs, a frantic drumbeat echoing in her ears. Buddy, sensing her heightened anxiety, pressed closer against her leg, his familiar warmth a small comfort. Across the aisle, Mrs. Henderson sat ramrod straight, flanked by Mr. Thorne, her face a mask of practiced indifference, but Sarah could detect a flicker of nervousness in her eyes. David Chen squeezed Sarah's hand, a silent gesture of support. All the months of struggle, the endless paperwork, the grueling depositions, the raw emotional testimony. It all culminated in this one moment. Would justice be served, or would the HOA's arrogance and willful disregard for federal law prevail? The judge, his voice calm and authoritative, cleared his throat. "Ladies and gentlemen of the jury, have you reached a verdict?" "We have, Your Honor," the foreperson replied, her voice clear. The bailiff passed the paper to the judge, who unfolded it deliberately, his gaze scanning the words. The seconds stretched into an eternity. Sarah held her breath, her gaze darting between the judge's impassive face and the jury, searching for any telltale sign. Buddy let out a soft, almost imperceptible sigh, as if he too was holding his breath. Finally, the judge looked up, his eyes meeting Sarah's for a fleeting moment. "In the case of Jenkins versus Lakeshore Heights Homeowners Association," he paused, and the air crackled. "We, the jury, find in favor of the plaintiff, Sarah Jenkins." A collective gasp rippled through the courtroom. Sarah felt a wave of dizzying relief, so powerful it almost buckled her knees. Buddy let out a quiet woof and licked her hand. Tears welled up in her eyes, blurring the faces around her. David Chen let out a controlled exhale, a slight victorious smile touching his lips. Across the room, Mrs. Henderson's carefully constructed composure crumbled. Her face contorted in disbelief, and Mr. Thorne quickly leaned over to whisper to her, his own expression one of stunned defeat. The victory was clear, resounding. The judge continued, reading the specifics of the verdict. The jury finds that Lakeshore Heights Homeowners Association violated the Americans with Disabilities Act by failing to provide reasonable accommodation and engaging in discriminatory practices. We award the plaintiff, Sarah Jenkins, $50,000 in damages for emotional distress, financial losses incurred, and the cost of the towed vehicle and accumulated impound fees. $50,000. It wasn't just a number. It was validation. It was recognition of the hardship, the insult, the injustice. It was a statement that her independence, her dignity, and her rights mattered. Outside the courtroom, the small cluster of reporters who had followed the case swarmed Sarah and David. "Ms. Jenkins, how do you feel? What does this mean for other disabled residents?" Sarah, still a little shaky but radiating quiet strength, stood tall. "This verdict is not just a win for me," she said, her voice clear and steady. "It's a win for every individual with a disability who has faced discrimination or had their rights challenged. The Americans with Disabilities Act exists for a reason, to ensure equal access and opportunity. This lawsuit was about holding power accountable and proving that our independence is not negotiable." She gently patted Buddy's head, who leaned proudly against her leg. "My service dog and my accessible van are essential to my life. Today, justice was served, not just for me, but for the principle of accessibility itself." David Chen stepped forward. "This case sends a clear message to HOAs and other entities. Federal disability laws are not suggestions. They are mandates. We hope this verdict encourages all communities to educate themselves on their obligations under the ADA and Fair Housing Act, and to treat all residents with the dignity and respect they deserve." The legal ramifications for Lakeshore Heights HOA were significant. Beyond the monetary award, the judgment likely compelled them to immediately update their parking policies to explicitly include reasonable accommodations for accessible vehicles and service animals, provide mandatory disability sensitivity training for all HOA board members, management, and staff, install clear, legally compliant accessible parking signage throughout the community, potentially face ongoing monitoring by the court to ensure compliance. The HOA, through Mr. Thorne, initially announced their intent to appeal. But after further legal review and facing the overwhelming evidence presented at trial, they ultimately decided to drop the appeal, realizing it would be a prolonged, costly, and ultimately losing battle. They paid the judgment and began the arduous process of revising their policies. For Sarah, the aftermath was a journey of healing and reclaiming her life. The van was returned, washed clean of the impound lot's grime, its ramp once again extending smoothly, a symbol of her regained freedom. The financial award, while not making her rich, provided a vital cushion, allowing her to catch up on bills and even make a few long-delayed improvements to her home to further enhance her accessibility. But the most profound change was internal. The lawsuit had been exhausting, emotionally draining, but it had also forged a new sense of empowerment within her. She was no longer just the veteran with PTSD who needed a service dog. She was also the woman who stood up to injustice and won. Inspired by her own ordeal, Sarah began volunteering with Advocates for Independent Living, the same organization that had helped her. She shared her story, spoke at community meetings, and mentored other individuals with disabilities facing similar battles with HOAs or landlords. Her voice, once quivering with frustration, was now a beacon of advocacy, helping others navigate the complex legal landscape of disability rights. Her relationship with the Lakeshore Heights community slowly began to mend. Some residents, who had initially been swayed by HOA propaganda, approached her, offering apologies and expressing newfound understanding. The HOA itself, though still managed by Mrs. Henderson, who was now notably more subdued and compliant, seemed to operate with a new awareness, albeit a reluctant one, of its legal and moral obligations. The story of the HOA that towed a service dog's accessible van became a powerful testament to the Americans with Disabilities Act. It was a reminder that laws exist to protect the most vulnerable, and that every individual has the right to live with dignity and independence. Sarah, with Buddy faithfully by her side, continued to drive her accessible van, not just through the gates of Lakeshore Heights, but through life, a symbol of resilience, justice, and the unwavering spirit of independence. Her fight had not just won her a case. It had paved the way for a more accessible and understanding future for countless others.